How to Succeed in Private Children Law Proceedings, a Parent's Guide. Hello, and welcome to Family Law Nugget, produced by Chris Aniche, a children's law accredited solicitor with Curling Moore Solicitors Advocates. I'm going to share insights, strategies, and real stories to help you navigate this difficult journey with confidence and focus on what truly matters: your children's well-being. Whether you're just beginning this process or you're already deep in court proceedings, this guide will provide practical advice to help you succeed. So let's get started. Understanding private children law proceedings. Private children law proceedings might sound intimidating, but they're simply court cases where parents or carers who can't agree on arrangements for their children seek the court's help to decide. These typically happen after separation or divorce, when tensions are already high and emotions are raw. You know that feeling when you're trying to have a reasonable conversation about pickup times, and suddenly you're rehashing old arguments? That's exactly why these proceedings exist, because sometimes, despite our best intentions, we need an objective third party to help us focus on what's best for our children. These proceedings involve applications for orders such as child arrangements, orders that determine where a child lives and who they spend time with; specific issue orders for decisions on particular aspects of a child's upbringing; prohibited steps orders that restrict certain parental actions. 5. The reality of family court. I remember speaking with James, a father of two, who initially approached his case with combative energy. I went in thinking it was like those courtroom dramas on TV, he told me. I was ready to win and prove I was the better parent. 3 hearings later, I realized the court wasn't interested in crowning a winner. They wanted to know who could best focus on their children's needs. This is such an important distinction. The family court isn't about winning or losing. It's about finding arrangements that serve your children's best interests. Once you truly understand this, your approach will shift dramatically. Key principles that guide the court. The court follows specific principles when making decisions about children. Understanding these will help you align your case with what judges are looking for. The court considers several factors known as the welfare checklist. Your child's wishes and feelings, considered based on their age and understanding. Their physical, emotional, and educational needs. How changes might affect them. Their age, background, and relevant characteristics. Any harm they've suffered or risk suffering. How capable each parent is of meeting their needs. The range of powers available to the court. Understanding these principles means you can frame your evidence and arguments to address what the court is actually looking for, rather than focusing on adult conflicts. Preparing your case. Document, document, document. Let me tell you about Sarah, who was frustrated when her ex-partner repeatedly canceled or was late for contact visits. Rather than just complaining about his unreliability, she kept a detailed log of every scheduled visit, noting when he was late, when he canceled, and how their daughter reacted each time. When I presented this to Cafcass and eventually the court, she shared, it wasn't about attacking him. It was about showing a pattern and how it affected our daughter. I suggested a more realistic schedule that he could stick to, which the court eventually ordered. The key lesson? Document everything, but do so with purpose. Focus on patterns and how they affect your child rather than collecting ammunition against the other parent. Prepare for Cafcass involvement. Cafcass plays a crucial role in private children proceedings. They provide independent advice to the court about what arrangements are likely to be in your child's best interests. 5. Their recommendations carry significant weight, so your interactions with them matter tremendously. Before meeting with a Cafcass officer, plan what you want to say about your case. Prepare for questions about the other side's claims. Stay calm, even when upset or angry. Be honest and open. Focus on your child and their needs. Be clear about what you want the court to do. Highlight positive aspects of your relationship with your child. Explain concerns in terms of their impact on your child. I spoke with Michael, who initially approached his Cafcass interview like a battle. I went in ready to list all my ex's flaws, he admitted. But my solicitor advised me to instead focus on my relationship with my son and my parenting plan. The difference in the Cafcass officer's response was night and day. The conversation became constructive when I focused on my son rather than my grievances. The first hearing. Walking into court for the first time can be intimidating. The formal environment, legal terminology, and high stakes create anxiety for most parents. Practical tips for court appearances. Arrive early, typically 30 to 60 minutes before the hearing time. Dress professionally but comfortably. Bring all relevant paperwork organized in a folder. Arrange childcare. Children should not be brought to court. Consider transportation and parking in advance to avoid rushing. Emma, a single mother, shared, "For my first hearing, I was so nervous I barely slept. I arrived with minutes to spare, flustered and disorganized. The judge noticed, and I felt I started on the back foot. For the second hearing, I arrived an hour early, had time to review my notes, speak with my solicitor, and compose myself. I felt much more confident and presented my case more effectively." Effective communication in court. How you communicate in court significantly impacts how your case is perceived. Remember, you're not performing for drama. You're demonstrating your ability to put your child first. When giving evidence, speak directly to the judge, not the opposing lawyer. Keep answers as short as possible. If yes or no will suffice, just say that. Speak slowly, clearly, and loudly enough to be heard. If you make a mistake, admit it, correct it, and move on. Maintain positive body language. Tom, a father fighting for more time with his daughter, learned this the hard way. "In my first hearing, I got into arguments with my ex's barrister, interrupted, and tried to tell my whole life story with each answer. The judge kept asking me to be more concise. My friend who attended said I came across as confrontational rather than cooperative. For the next hearing, I practiced giving short, direct answers, and the difference was remarkable." Working with legal professionals. Whether you have legal representation or are representing yourself, a litigant in person, understanding how to work effectively with legal professionals is crucial. If you have a solicitor or barrister, be honest and thorough when briefing them. Listen to their advice, even when it's not what you want to hear. Provide documents promptly when requested. Use their expertise strategically. They know the system. Remember, they are not therapists. Keep emotional venting separate from legal strategy. If representing yourself, research court procedures thoroughly. Keep your opening statement concise and factual. Prepare questions for witnesses in advance. Take notes during proceedings. Be respectful of court etiquette and procedures. I recall meeting David, who initially dismissed his solicitor's advice because it didn't match his emotional need for justice. "I wanted my day in court to expose my ex's behavior," he explained. "My solicitor kept pushing me to focus on practical arrangements and compromise. I eventually realized she wasn't working against me. She understood what would actually help my case succeed." The child's voice in proceedings. One of the most consistent findings in research is that children often feel unheard in private law proceedings, which causes them significant distress. This presents an opportunity for you to stand out as a parent who genuinely prioritizes their child's perspective. Research shows that children want to be more involved in decision-making when their parents separate, often feel left in the dark about what is happening, feel the court is focused on parental conflict rather than their lives, experience distress when they feel their views aren't considered. However, children also express concern about being asked to choose between parents or carrying the burden of the final say in decisions. Lisa approached this thoughtfully with her 10-year-old son. Instead of asking leading questions like, "You want to live with me, right?" I created space for him to express his feelings about both homes. I documented his comments neutrally and shared concerns he raised with appropriate professionals. The Cafcass officer noted this approach positively in her report. Handling allegations and high-conflict situations. Some private law cases involve serious allegations, particularly around domestic abuse, coercive control, or child safety concerns. These cases require special consideration. In recent years, courts have increasingly recognized the need to focus on patterns of behavior rather than just specific incidents, particularly with coercive and controlling behavior. If you're facing allegations, respond factually and calmly. Focus on evidence rather than emotional denials. Address concerns directly rather than deflecting. Consider whether therapeutic or educational interventions might help. Remain child-focused in all responses. If you're raising concerns, document patterns of behavior and specific incidents. Focus on the impact on the child rather than personal grievances. Be prepared to explain the relevance to child welfare decisions. Consider what safeguards might address the concerns while maintaining appropriate relationships. Mark faced allegations of controlling behavior from his former partner. My initial reaction was defensive anger, he admitted. But my counselor helped me see that proving my ex wrong wouldn't help my relationship with my children. Instead, I focused on demonstrating my parenting capabilities, completed a parenting course voluntarily, and proposed a gradual contact plan that addressed some of her genuine concerns. The court responded much more positively to this approach. Cafcass assessments and Section 7 reports. A Section 7 report is often ordered by the court to help them make decisions. These reports, usually prepared by Cafcass, assess the child's welfare and make recommendations about arrangements. Making the most of the Cafcass assessment. Be prepared for your Cafcass interview. Have photos, activity schedules, or other evidence of your involvement with your child ready. Create a suitable environment if they're visiting your home. Let your child know, in age-appropriate terms, who Cafcass is and why they're speaking with them. Never coach your child on what to say. Jennifer was initially frustrated with her Cafcass assessment. The officer spent 30 minutes with me but seemed to accept everything my ex said at face value, she recalled. Rather than complaining, I politely requested a follow-up meeting and came prepared with school reports, medical records, and a detailed parenting plan. I stayed calm and child-focused. The final report was much more balanced after I provided this additional context. Navigating court orders and directions. Throughout proceedings, the court will issue various orders and directions that must be followed precisely. Missing deadlines or failing to comply with court orders can seriously damage your case. Practical tips for compliance. Create a calendar with all court deadlines clearly marked. Set personal deadlines a few days earlier to allow for unexpected issues. Read all court orders carefully and seek clarification if anything is unclear. Keep copies of all documents submitted to the court. Document your compliance with interim arrangements. Robert learned this lesson through a difficult experience. I misunderstood a court direction about providing financial information and submitted it late, he shared. The judge was noticeably less sympathetic to my position afterward, and my ex's solicitor referenced my noncompliance repeatedly. Something so seemingly administrative affected how my entire case was perceived. Showing your parenting capabilities. Courts want to see evidence of your ability to meet your child's needs. This isn't just about loving your child. It's about demonstrating practical parenting skills. Effective ways to demonstrate parenting capability. Maintain appropriate housing for your child. Show knowledge of their educational needs and involvement with their school. Demonstrate understanding of any special needs or health issues. Keep a record of activities you do together. Show willingness to facilitate relationships with extended family. Demonstrate cooperation with the other parent where possible. Sam had limited contact with his children when proceedings began. I realized I needed to prove I could provide stability, he explained. I adjusted my work schedule to accommodate school pickups, attended every parent-teacher conference, and sent respectful updates to their mother afterward, and took parenting classes. The Cafcass officer noted my commitment to adapting my life around my children's needs. Managing emotions throughout the process. Private children proceedings are emotionally exhausting. The combination of legal stress, financial pressure, and concern for your children creates a perfect storm of anxiety. Strategies for emotional management. Establish a support network separate from your legal advisors. Consider counseling or therapy during the process. Develop specific stress management techniques. Compartmentalize. Set aside dedicated time for case preparation. Then allow yourself breaks. Join support groups with others experiencing similar challenges. Focus on long-term goals when short-term setbacks occur. Amanda described her emotional journey. I initially channeled all my anger at my ex into the court case. My solicitor eventually told me bluntly that my emotions were clouding my judgment. I started working with a therapist and joined a support group for separated parents. Having space to process these feelings separately helped me approach court with a clearer head. Dealing with setbacks. Few cases proceed perfectly smoothly. Court dates get delayed, assessments take longer than expected, and interim arrangements may not be what you hoped for. Responding to setbacks effectively. Distinguish between minor inconveniences and significant issues. Focus on constructive responses rather than assigning blame. Consider alternative solutions to propose. Document any impact on your child for future reference. Maintain strict compliance with any interim arrangements despite disappointment. Chris experienced repeated delays in his case. Each postponement felt devastating because I was missing time with my daughter, he recalled. My solicitor advised me to use this time constructively. I updated my parenting plan, completed a positive parenting course, and kept a journal of all contact. When we finally reached the hearing, I had 6 months of additional positive evidence to present. Success stories from real cases. Let me share some success stories that illustrate effective approaches. One father described his success after a 2-year court case involving child relocation. The mother had moved his son 300 miles away. By representing himself effectively, maintaining a positive attitude toward the mother's parenting, and being realistic in his requests, he eventually secured favorable contact arrangements, including overnight stays much earlier than the mother had proposed. Another parent succeeded by focusing on documentation and pattern recognition. When her ex-partner consistently returned their child late and ignored agreed boundaries, she kept meticulous records. Rather than making it about the other parent's character, she presented evidence showing how the inconsistency affected their child's sleep, school performance, and anxiety levels. The court instituted specific handover times with consequences for noncompliance. A third case involved a father who initially had supervised contact only. By focusing on incremental progress, completing recommended parenting courses, and demonstrating consistent commitment to scheduled visits, he gradually built a case for expanded contact. His willingness to start with modest proposals and prove himself over time ultimately led to substantial unsupervised time with his children. Implementing court orders successfully. Receiving a final order isn't the end of the journey. Implementing it successfully requires continued effort and cooperation. Tips for successful implementation. Create a shared calendar for contact arrangements if possible. Establish clear communication channels about the children. Document compliance and any issues that arise. Consider using co-parenting apps if direct communication is difficult. Focus on consistent routines to help children adjust. Be flexible where appropriate while maintaining boundaries. Maria and her ex-husband struggled with implementing their court order until they adopted a business-like approach. We created a shared digital calendar, started using a co-parenting app for messages about the children, and established clear handover protocols, she explained. Removing the emotional aspect of our interactions and focusing on consistency dramatically reduced conflicts. When to consider returning to court. Court orders aren't always permanent. Circumstances change, children grow older, and arrangements may need adjustment. Situations that might warrant returning to court. Significant changes in either parent's circumstances. The child's needs evolving with age. Persistent noncompliance with existing orders. Safety concerns that weren't present previously. Positive improvements that support expanded arrangements. However, courts generally prefer parents to resolve issues without repeated litigation. Before returning to court. Document attempts to resolve issues cooperatively. Consider mediation or other dispute resolution methods. Ensure you've strictly complied with existing orders. Be prepared to demonstrate why changes would benefit your child. Final thoughts: the long-term perspective. As we wrap up, I want to emphasize the importance of taking the long view. These proceedings may feel all-consuming now, but they're just one chapter in your child's life. Parents who succeed in private children law proceedings aren't necessarily those who win every point, but those who keep their children's needs at the center of all decisions, demonstrate flexibility and cooperation where possible, present themselves as solution-focused rather than conflict-driven, show commitment to ongoing positive co-parenting despite difficulties, focus on building relationships rather than winning arguments. Remember James from earlier? 5 years after his contentious court battle, he reflected, "Looking back, the details we fought over seem so insignificant now. What mattered wasn't the exact hour of pickups or who bought the school shoes. It was creating an environment where our kids felt loved and secure with both parents. Had I understood that from the beginning, I would have approached the whole process differently." Your goal isn't just to navigate these proceedings successfully, but to lay the groundwork for positive family relationships long after the court process ends. Your children will remember not just the outcomes, but how you conducted yourself throughout this challenging time. Thank you for joining me for this guide to succeeding in private children law proceedings. I hope these insights, strategies, and stories help you navigate your own journey with confidence and clarity. Remember, at the heart of every technical legal process are real children who need the adults in their lives to put their needs first. Good luck, and keep focusing on what truly matters: your children's well-being. Subscribe and share with those who could benefit from this insight. My name again is Chris Aniche, Specialist Accredited Solicitor, Family Law Nuggets. Thank you.